Thousands of cases are heard in American courts every year as citizens exercise their rights in our court system. I think you'll find this next case very interesting. I'm Brian Hagg with this week's It's a Matter of Law. In this case, a man in Ohio was being investigated by the government for money laundering and other federal crimes. The government obtained a court order that directed two commercial internet service providers to turn over information regarding their customers' email account. Included in the court's order was a demand by the government to release individual emails sent by the suspect. The suspect was not notified of the order until after the government had obtained the information. Upon finding out that the emails were in the hands of the government, the man filed suit seeking declaratory and injunctive relief, alleging, among other things, that the seizures of the email without a warrant violated his constitutional rights against unlawful search and seizure. The government argued that there was no reasonable expectation of privacy by the suspect. Thus, his Fourth Amendment rights were not violated. How would you decide this case? Do individuals have a reasonable expectation of privacy over their personal emails if they have an account through a commercial internet service provider? We'll be back in a moment with the answer to that question. Do individuals have a reasonable expectation of privacy over their personal emails if they have an account through a commercial internet service provider? Yes, according to the Sixth Circuit United States Court of Appeals. This case is about whether internet service providers must hand over personal emails of individuals who use their email services. The court ruled that email users do have a reasonable expectation of privacy in the content of their emails. And the internet service provider is merely an intermediary and cannot be compelled to turn over the emails without a search warrant or court order. The court outlined three ways investigators may obtain the email information. Number one, because of the email user's reasonable expectation of privacy, the government must show probable cause, and thus must obtain a warrant to procure the information. Or number two, they must show that the email user explicitly waived his or her expectation of privacy by an agreement with the internet service provider, giving the provider total access. Or number three, the email user must be given notice of the government's desire to obtain the emails, and the user must be afforded an opportunity to contest the government's request. Although this case stems from a federal appeals court in Ohio, it is an issue that will likely be taken up by the United States Supreme Court. We will continue to monitor this issue as it progresses. Remember, it's a matter of law.